At 8:47 a.m. Eastern Time, United States Marshals arrived at Mar-a-Lago, not for a search, not for an arrest, not for spectacle. They arrived with paperwork, specifically a court-ordered writ of execution, authorizing the federal government to begin seizing assets to satisfy unpaid civil judgments totaling more than $500 million. 3 US Marshals, 4 professional appraisers, local law enforcement for perimeter support. No confrontation, no shouting, just enforcement. Before assuming this was unprecedented political retaliation, it's important to understand what a writ of execution actually is, and why this moment, while extraordinary in scale, is routine in law. A writ of execution is not a punishment, it is not discretionary, it is not political. It is the final step in civil litigation when all other options have been exhausted. When someone loses a civil case, is ordered to pay damages, appeals the decision, loses those appeals, and still does not pay, the court authorizes law enforcement to seize assets and liquidate them to satisfy the debt. That's not an escalation. That's the process. And that process has been unfolding methodically for months. The timeline matters. On February 16, 2024, a New York judge entered a civil fraud judgment against Donald Trump, ordering him to pay $355 million in disgorgement, money the court found was obtained through systematic financial misrepresentation, plus interest accruing at 9% annually. Less than a month later, on March 8, 2024, a federal jury awarded $83.3 million in damages in a separate defamation case. Combined, the judgments totaled approximately $438 million. But civil judgments don't sit still. With statutory interest accruing daily, the amount owed grew rapidly. Over 9 months, interest alone added more than $70 million. By the time enforcement began, the total obligation stood at roughly $512 million, and rising by approximately $130,000 every single day. Appeals were filed. That part is expected. But in New York, appealing a civil judgment is not free. The law requires a defendant to post a bond, typically 110% of the judgment, to ensure payment if the appeal fails. For these judgments, that bond requirement totaled approximately $480 million. The deadline came and went. A bond was posted for the defamation judgment. None was posted for the fraud judgment. The defense asked the court to waive the bond requirement. The court declined. The law is explicit. Without a bond, the judgment may be enforced immediately. This is where abstraction ended. For months, the story lived in motions, briefs, and procedural language, conditional verbs, hypotheticals, if granted, if affirmed, if enforcement becomes available. It all felt distant, legal machinery humming quietly in the background. Then June arrived. Judgment creditors filed motions asking for permission to do something far more concrete, begin taking assets, not discussing liability, not arguing intent, simply enforcing what the court had already decided. The request was blunt: authorization to seize. By August, the court answered. Enforcement could proceed. Asset discovery was authorized. That ruling changed the posture of everything. This was no longer about winning or losing arguments. It was about locating value, about turning judgments into numbers, numbers into property, property into leverage. September followed quickly. Subpoenas went out, not to headlines, but to institutions, banks, property registries, corporate entities, the places where wealth leaves fingerprints. October deepened the picture. Accounts were identified, ownership structures untangled, revenue streams traced. What had once been brand names and public symbols became line items: Mar-a-Lago, Trump Tower, golf courses across multiple states, licensing agreements, bank accounts. Each name carried weight, not because of its symbolism, but because of its vulnerability. Assets don't argue, they don't spin. They either exist or they don't. On October 9th, the appellate division closed another door. The fraud appeal was denied. There were no further state appeals available, no procedural off-ramp, no reset. What remained was finality. 2 weeks later, another deadline passed quietly but decisively. The window to appeal the defamation judgment closed. No Supreme Court appeal was filed, no extension requested. No last-minute intervention. With that silence, both judgments hardened. They were no longer pending, no longer contested, no longer theoretical. They were final. Final judgments do something unique in the legal system. They strip away narrative, they end debate, they turn power into math. On November 1st, the next step followed naturally. Judgment creditors filed for writs of execution in New York and Florida. This wasn't escalation, it was procedure. The inevitable consequence of everything that had already happened. Execution is a clinical word. It doesn't imply drama. It doesn't require outrage. It simply authorizes enforcement, and enforcement is mechanical. 6 days later, Florida responded. On November 7th, a Florida court issued the writ. It authorized enforcement at Mar-a-Lago. Not commentary, not symbolism, authorization. At that moment, the process reached a phase that courts do not reverse casually. Asset seizure is not punishment. It is not political. It is arithmetic enforced by law. What makes this stage unsettling is not what it represents, but how quietly it arrives. No speeches, no emergency rulings, no chaos, just filings, deadlines, and orders stacking neatly on top of one another. This is how power actually shifts in the legal system, not in explosions, but in increments, each ruling narrowing options, each missed appeal removing oxygen, each authorization converting theory into action. By the time the writ was issued, the outcome was no longer speculative, it was procedural. The system wasn't debating what should happen, it was executing what already had. That is the moment everything changes. Not when accusations are made, not when appeals are argued, but when enforcement begins. Because once the law moves from words to property, there is no more pretending the conflict is abstract. It becomes real. And this morning, 9 months after judgment, federal marshals arrived to execute it. At every step, alternatives existed. Pay the judgment, post the bond, negotiate a payment plan, liquidate assets voluntarily. Instead, the strategy was delay. Delay has a cost. In this case, approximately $41 million. Now comes the legal question many people immediately asked: can Mar-a-Lago actually be seized? Florida law provides strong homestead protections. A primary residence is generally shielded from seizure to satisfy civil judgments. But Mar-a-Lago is not legally classified as a private residence. It is a private club. That distinction is not semantic, it's dispositive. In 1993, Donald Trump signed a formal agreement with the town of Palm Beach converting the property from a private residence into a private club. That agreement imposed restrictions, including limits on how many days per year he could reside there. The property operates as a commercial business. It charges initiation fees, it collects annual dues, it hosts weddings, galas, political fundraisers, and events. Florida courts have consistently held that properties operating as businesses do not qualify for homestead exemption, even if the owner occasionally resides there. Under Florida precedent, Mar-a-Lago is not what it is marketed as. It is a club with residential quarters, not a private residence with incidental commercial use. That distinction is not cosmetic. It is legal, and it matters, because classification determines exposure. Once a property is defined as a commercial operation, the rules change. Protections narrow, assumptions collapse. What feels untouchable becomes inventory, and inventory can be seized. The first category is straightforward: business assets, furniture, fixtures, kitchen equipment, point-of-sale systems, golf carts, maintenance vehicles, event infrastructure, inventory tied to operations. Anything used to generate revenue is subject to execution. Courts do not debate sentiment here. They follow function. If an item supports commercial activity, it is an asset. If it is an asset, it can be taken. That alone reshapes the property. Mar-a-Lago is not just a building, it is an operating enterprise. weddings, dinners, memberships, events. The physical tools that make those possible are not shielded by branding or symbolism. They are business property. The second category is where things become more uncomfortable. Personal property located on commercial premises. This is where perception breaks down. Artwork displayed in ballrooms, antiques placed in dining rooms, decorative furnishings lining hallways and common areas. If an item is located within the operational space of a club, it does not matter how personal it feels. Location matters more than intent. Courts look at where the item is displayed and how it is used, not how it is described. If it enhances the club experience, it is part of the operation. Reports indicate artwork valued in the millions is displayed throughout Mar-a-Lago, not hidden, not secured in private quarters, displayed, integrated, visible to members and guests. If those works are owned by the defendant and placed in club areas, they are not abstract prestige objects. They are tangible assets. Assets can be appraised, assets can be cataloged, assets can be removed. This is not hypothetical. This is routine enforcement logic applied to an extraordinary location. The third category is the most consequential. The real property itself. Seizing land and buildings is not fast. It requires additional proceedings, valuations, notices, hearings, often months, sometimes years. But it is legally possible. Homestead protections are powerful in Florida, but they are not automatic. They depend on classification, primary residence, exclusive personal use, absence of commercial activity. Mar-a-Lago complicates all of that. It is a revenue-generating club. It hosts members. It employs staff. It markets itself publicly. If a court determines that homestead protections do not apply, the shield disappears. The property becomes subject to enforcement like any other commercial real estate, not quickly, not quietly, but lawfully. This is where the irony sharpens. For years, the property's commercial identity was its strength. A symbol, a brand, a stage, proof of success, proof of permanence. That same identity now creates vulnerability. Had it been a simple private residence, protections would be broader, arguments cleaner, boundaries clearer. Instead, its dual nature, part club, part home, creates friction. And friction is where courts intervene. Every ballroom matters, every membership contract matters, every revenue stream becomes relevant. Enforcement does not arrive dramatically, it arrives methodically, through inventories, through valuations, through writs executed by officers who do not negotiate with mythology. They follow orders. There is no spectacle in that process. Just removal. Just documentation. Just empty spaces where objects once stood. The irony is not just legal, it is symbolic. The same openness that turned Mar-a-Lago into a public stage now exposes it to public consequence. The same visibility that amplified its power now clarifies its risk. This is what happens when image and structure collide. And once courts begin treating symbols as assets, the transformation is irreversible. Not because of politics, not because of narrative, but because precedent has already decided what the property is, and what it is can be seized. For years, Trump publicly claimed Mar-a-Lago was worth over $1 billion. The fraud judgment found those valuations were inflated. Court-appointed monitors estimate the property's actual value between $200 and $400 million. Independent appraisers will determine fair market value based on comparable sales, revenue, restrictions, and zoning. The process is not dramatic. Marshals do not guess. Appraisers do not speculate. They catalog, they measure, they photograph, they research, room by room, item by item. Even if every movable asset at Mar-a-Lago sold for $20 million, which would be generous, that represents roughly 4% of the total judgment. Which raises the obvious question, where does the rest come from? Mar-a-Lago is not the only target. Asset discovery did not stop at one courthouse or one jurisdiction. It widened, quietly, methodically. What began as paperwork became a map, Properties and accounts surfaced across multiple states and countries, each one a dot connected by court orders, subpoenas, and compliance deadlines. This is how enforcement really works. Not with spectacle, but with spreadsheets and signatures. Start with Trump Tower, the Manhattan penthouse, once presented as untouchable, valued by Trump himself at $200 million. Independent analysts place it lower, somewhere between 120 and 180 million, still enormous, still liquid enough to matter, and crucially, not protected. Homestead protection does not apply. Florida residency was claimed. New York law does not extend exemptions across state lines. That detail alone transforms a symbol into an asset. Then come the golf courses, New Jersey, Scotland, Ireland, not personal retreats, commercial operations. These are businesses with payrolls, memberships, vendors, and revenue. They file reports, they keep books, they depend on cash flow. Combined valuations hover around $400 million, depending on assumptions and market conditions. And commercial assets are exposed. They can be appraised, they can be liened, they can be sold under court supervision if necessary. There is no drama in this process, just time, paperwork, and inevitability. Next are the licensing deals, the quiet engine of the Trump brand, millions annually from name usage, buildings, products, ventures that pay for association. Those revenues are not abstract, they are contracts, and contracts can be redirected. Courts do not need to seize buildings to exert pressure. They can simply reroute income streams. Money that once flowed automatically can be intercepted, placed into escrow, or transferred to satisfy judgments. No press conference required, no confrontation necessary. Then there are the bank accounts, major institutions, domestic and international. If funds exist, and discovery suggests they do, freezing can happen fast. Days, not months. Once a writ is served and verified, compliance departments act first and ask questions later. That is how banks survive. Transfers follow, balances change, and the numbers move. This is the part that rarely makes headlines but changes everything. Asset seizure is not about punishment. It is about math. Judgments convert into obligations. Obligations convert into enforcement. Enforcement converts into liquidation if resistance continues. Every identified asset reduces maneuvering room. Every frozen account limits options. Every redirected revenue stream narrows the path forward. And there is a psychological dimension here that cannot be ignored. Power feels different when it is no longer abstract, when it is reduced to line items, when symbols become entries on a balance sheet. This is not political. It is procedural. The courts are not asking permission. They are executing orders. And once discovery reaches this depth, multiple properties, international holdings, recurring revenue, the question stops being if enforcement will happen. It becomes how much and how fast. That is the shift, not theory, not speculation, reality, itemized. When collecting a judgment of this size, enforcement follows a strategy. Liquid assets first, revenue streams next, illiquid real estate last. Bank accounts stop interest immediately. Licensing revenue reduces ongoing accrual. Property sales recover bulk amounts over time. Interest alone accrues at approximately $46 million per year. Every delay benefits no one except the meter. Legal challenges will continue. Appraisals will be disputed. Valuations contested. But the appeals are over. Every argument now is about how enforcement happens, not whether it happens. Now, what actually occurred this morning? At 8:47 a.m., 3 US Marshals, 4 appraisers, and 2 sheriff's deputies arrived at Mar-a-Lago's main gate. The lead marshal carried the court order authorizing entry. Security initially refused access. That is standard. Unexpected law enforcement arrivals trigger internal protocols. The writ was presented. Security called supervisors. Supervisors called management. Management called lawyers. For approximately 90 minutes, there was a pause. Not a standoff, but verification. Lawyers reviewed the writ, confirmed issuance, checked for pending stays, confirmed none existed. At 10:15 a.m., counsel concluded the writ was valid and enforceable. Florida law requires compliance. At 10:17 a.m., the gates opened. The appraisal team began in public areas only: ballrooms, dining rooms, corridors, common spaces. They photographed artwork, measured furniture, checked makers' marks, recorded condition and provenance. One appraiser was observed documenting a large landscape painting in the ballroom: artist, period, condition. Another measured an antique sideboard, checking manufacturer identifiers. The process was clinical, quiet, procedural. The marshals provided security. They did not appraise. By 1:30 p.m., public areas were cataloged. Private residential spaces were not entered. Those require separate authorization. The team departed around 2 p.m. after roughly 6 hours on site. Tomorrow, valuation begins. Appraisers will review auction databases, comparable sales, and market conditions. By next week, preliminary valuations will be submitted to the court. Creditors can then request authorization for auction. For someone accustomed to operating under the assumption that wealth creates insulation from consequences, having federal officers catalog possessions is a forced confrontation with reality. The law does not negotiate. When lawyers confirmed the marshal's authority, compliance was the only option. That is accountability: physical, immediate, unavoidable. This process will continue. Trump Tower next. New Jersey golf courses following. Slow, methodical, functional. This case establishes 3 important precedents. First, wealth does not confer immunity from civil enforcement. For decades, wealthy defendants relied on delay, complexity, and exhaustion: appeals, corporate shells, asset transfers, waiting out creditors. Sometimes it worked, but when creditors persist and courts enforce timelines, collection is possible, even at scale. Second, civil enforcement can achieve accountability where criminal prosecution cannot. No prison sentence exists here. But civil judgments carry powerful tools: seizure, dissolution, monitoring, lower burdens of proof, different remedies. Civil law is not soft law. It is enforcement law. Third, visible enforcement matters. Court filings are abstract. Marshals at a property are not. Visibility affects public trust. It affects creditor confidence. It signals that the legal system does not end at wealth or office. This is not guaranteed success, but it demonstrates that the path exists. Over the next 2 weeks, 3 developments matter most. First, appraisal valuations. By November 22nd, preliminary valuations will indicate whether Mar-a-Lago assets meaningfully reduce the judgment or whether focus shifts elsewhere. Second, legal countermoves. What the defense challenges reveals what they fear: classification, valuation, or seizure itself. Third, settlement negotiations. Sometimes seeing enforcement triggers payment talks. If negotiations begin, that signals enforcement is working. If not, litigation continues. The judgment was entered. Appeals failed. The law required enforcement. This morning, enforcement occurred. Not loudly, not theatrically, but lawfully. And that matters, because this is what accountability looks like when delay finally runs out.